If your country is not on the 2026 H2B list, does that mean automatic denial? Not necessarily. You may still qualify. You heard the hook, so what does that actually mean? Let's break down how eligibility works and when USCIS can still approve cases from non-listed countries. Not necessarily. There is something called discretionary approval, and in certain cases, USCIS may still approve a petition for a worker from a non-designated country. But this process is not automatic, not routine, and not guaranteed. Before we continue, this video is provided for general educational purposes only and does not constitute legal or immigration advice. Immigration laws change, and every case is different. Always consult a qualified immigration attorney for advice specific to your situation. Each year, the Department of Homeland Security publishes a list of countries whose nationals are eligible to participate in the H2B program. This list is typically published in November in the Federal Register. If your passport country appears on that list, the process generally proceeds normally. But if your country is not designated, that's where discretionary authority becomes relevant. While the H2B program typically requires workers to be from a list of designated countries, there is an important exception. Under U.S. immigration regulations, USCIS has the authority to approve a petition for a worker from a non-designated country, if doing so is determined to be in the interest of the United States. This discretionary approval acknowledges that sometimes a specific worker's skills or circumstances are uniquely beneficial, justifying an exception to the general rule. So what does this mean in practice? It means the employer can still file the petition, even for a national of an ineligible country. However, they must proactively and specifically request this consideration. This is not automatic. The request should be made in writing, often as part of a detailed cover letter accompanying the Form I-129 petition. USCIS then reviews the case individually and makes a discretionary determination based on the evidence provided. It is crucial to understand that this is not an entitlement or a guaranteed outcome. It is a case-by-case decision, and the burden of proof rests entirely on the petitioning employer to demonstrate why the approval serves the U.S. national interest. USCIS may consider factors such as cooperation between governments, visa overstay rates, compliance history. U.S. labor market needs broader national considerations. Important clarification: workers do not file H2B petitions directly. The U.S. employer files Form I-129 on behalf of the worker. If the worker's nationality is from a non-designated country, the employer must request discretionary approval within the petition. The burden rests with the employer and their legal counsel, not the worker alone. While discretionary approval is legally possible, it is not routine. Many employers prefer recruiting from designated countries because the process is more predictable. If your country is not on the list, do not assume automatic denial, but also do not assume automatic approval. Confirm with the employer's immigration counsel and understand the additional review involved. Navigating the complexities of the H2B program requires staying ahead of constant policy shifts. If you find this type of detailed breakdown helpful for your planning, consider subscribing to H2B Success Blueprint. Our platform is designed to be your single source of truth. We provide structured updates, in-depth policy explanations, and practical, actionable education about the H2B program. Our goal is to empower you with the knowledge needed to make informed decisions and maintain compliance with confidence. We'd love to hear from your experience in the comments below. Is your country currently designated, and would you still pursue an opportunity if it required this type of discretionary review? Your insights help the entire community. Thank you for watching, and I'll see you in the next update. Before we continue, please remember that this video is provided for general educational purposes only. It is not intended to be and does not constitute legal or immigration advice. The information we're sharing is designed to give you a broad overview of the H2B process. Immigration laws and policies are complex and can change frequently. Furthermore, every single case is different, with unique facts and circumstances that can significantly impact the outcome. For these reasons, it is essential to always consult a qualified immigration attorney for advice specific to your situation. A key point to understand is that prospective workers do not file H2B petitions directly. The process is initiated by the U.S. employer, who files Form I-129, petition for a non-immigrant worker, on behalf of the worker they wish to hire. Once filed, U.S. Citizenship and Immigration Services, or USCIS, reviews the case individually and makes a discretionary determination. This means that even if all the basic requirements are met, an officer has the authority to approve or deny the petition based on the totality of the evidence. If you find this type of detailed breakdown helpful for navigating the H2B landscape, consider subscribing to H2B Success Blueprint for more insights.